Okay, welcome back. Now, so far we have seen the main aims of a contract being to realize expectations, to guard against certain risks, to ensure smooth running of the commercial system, and to be an instrument of social control regarding employment, sale of goods or service, and consumer credit. We have seen that the elements of a contract must be that the parties had an intention to enter into a legally binding agreement, that one party made an offer to the other which was capable of being accepted, that the other party accepted the offer unconditionally, that there was an exchange of monetary consideration, that the terms of the contract were sufficiently certain. In other words, everything was spelt out, what you're going to get. If it's service, if it's goods, then you're buying a television, that should work. When you take it home, it works. You're getting service. In service, it's not goods, so service can be a little bit more vague. But with services, they must spell out quite clearly what you're getting. Okay, what you're getting and what it will cost. You accept it and you pay, and that's it. If at the end of the day, what is set out on paper is not what you got, if the television that you bought does not work when you take it home because technically it is not fit for working, it does not work because there are mechanical parts to the set which stops it from working, so therefore it's faulty. Service, on the other hand, is far more vague. You can't look at it in your hand, you can't turn it up inside out and see that it's working. You can't plug it in before you take it home to make sure it works. So when it's service, it's different. If you are employing the services of an electrician or a plumber, it should set out quite clearly what the electrician or the plumber is capable of doing. You see that either on his website or he will send you a list of his services. You will see that he's able to unplug drains so that the drain is flushed through and is cleaned, and therefore he is able to do the job that you want. But if it's an electrician who is only able to work on certain appliances, you have a Zanussi fridge freezer, or you have a Hoover or any other of these brand names, you have a Sanyo television, but the repair person doesn't work on Zanussi appliances, they don't work on other makes or brands which you don't have, then you would see those services listed. So you would not expect that when you call them out to fix your fridge freezer, which is a different brand to what he works on, that he will be capable of doing it, simply because different parts operate different models. Okay, so just because they are electricians, you can't just assume that they're going to be able to fix or work on every aspect of appliance. All right, so you do make sure that what you are entering into is really what you want. It's capable of being accepted, and that the terms were sufficiently certain. He will say to you when he comes to your house, he says, well, I don't fix Zanussi freezers, or whatever the brand is, Indesit or Comet or Candy or any of the millions of brands that we see on the market shelves. Now, the fact that you looked at the website and you saw that he fixed fridges and freezers, you called him out anyway. He doesn't fix your particular brand of appliance. He may say to you, well, I'm sorry, but you still have to pay out my call out. You have to pay my call out charge, because the mistake was yours, assuming that XYZ is capable or was certain. And he will say to you, well, on my website or on my service list, I set out the type of appliances on which I'm able to repair or to carry out repairs. So if you didn't see that, he has made his terms sufficiently certain. He works on this make, this make and this make. The fact that it is still a fridge that you have that needs to be repaired doesn't necessarily mean he's able to do that job or he wants to do that job. Okay? So that the terms were sufficiently certain and that the contract was legal. We have now seen as an introduction to contracts that if there are gaps in a contract, those gaps could be filled by references to either customary practices or matters of previous dealing between the parties. If not, the court may conclude that the lack of certainty rules against the validity of the contract. So we are able to see that vagueness, if an agreement is too vague to permit a meaning to be given to it, it is not enforceable. The courts, however, might be able to find a meaning as to what appears to be a vague term by finding references to custom or previous dealings. So if we're talking about a clause in an agreement stating that the contract was for the sale of wood or fair speculation, because the parties to the contract were fully acquainted with the particular trade, the court was able to affix meaning to the phrase of fair speculation, and the contract was accepted as having reference to customary practice. But as I said during the introduction, if there is no history of previous dealings, if there is no reference to customary practices, then the contract is too vague, too unspecific. Okay, new heading, incompleteness. Incompleteness. If there is an essential term yet to be agreed, and there is no express or implied provision for a solution, there is no binding contract. Example: an agreement which says that the price is to be paid and the date of payment should be, in quotes, agreed upon from time to time, unquotes, by the parties shows that there was never a concluded contract between the parties. Full stop. So again, you can see incompleteness is a problem, just as vagueness is a problem, because incompleteness doesn't give you a specific time to pay, maybe every 2 weeks, at the end of every month, or at the beginning of the transaction, or half at the beginning of the transaction, or half at the end of the transaction, or all of it at the end, or all of it at the beginning in advance. So if again we are looking at specifics being omitted, the contract can be deemed incomplete. So the example of an agreement stating that the price is to be paid, you don't even know what the price is, and the date of payment should be agreed upon from time to time by the parties, shows incompleteness. Okay, it shows that there was never a concluded contract between the parties. So the first thing we've seen is a contract which could be vague, but could still be legal or valid because of previous custom, previous practice. Now we have seen incompleteness, and it shows that there was never a concluded contract between the parties if it simply states that the price to be paid and the payment should be made or agreed from time to time by the parties. Okay, full stop. If, however, previous arrangements existed which had the parties agreeing periodically when payment should be made, that previous customary practice will be taken into account. Full stop. So you can see now quite clearly that previous practices, previous customs, previous dealings, how important that is, because those previous practices or dealings will go to show that the parties are familiar with how they operate between themselves. There may not be a payment date stipulated within the contract, but because they are already familiar with each other, one maybe every 2 weeks they may write and ask for payment, and you have made those payments. Because it doesn't state in the contract that you should be paid or payment should be made every 2 weeks. Because you've done it before, and you know that ever so often he will write to you or phone you up and say, can I have the next payment now, please? That is accepted. The contract is valid. It's enforceable because you are used to it. But again, if there's no previous history, if there is no custom, then again the parties may not understand what each other offered and what each other accepted, and therefore it will seem simply to be unenforceable. Okay, so we have seen vagueness, now we have seen incompleteness, but this will only go to make a contract invalid if there is no previous dealings. If all the questions have been answered and you are satisfied that I am able to make a payment every 2 weeks, even though it's not written in a contract, it is still valid. All right. New heading, statute. New heading, statute, which is law. Whenever you see the word statute, it means the law. If you see statutory, it's in relation to legal, to something being legal or the law in general. So statute basically is another word for law. Okay, statute. Certain agreements. Certain agreements which are concluded under statute, such as the Sale of Goods Act, Consumer Protection Act, or contract for sale of land must be in writing to be enforceable. Okay, full stop. Now, when we're looking at these particular types of contract, the Sale of Goods Act means you walk into a shop, and as I was saying earlier, if you were to buy a TV set, although you are not given a contract that says this television is sold with ability to show up to 15 channels, it must be sold with remote control, and so on and so forth. It must be able to show in clear vision when it's working. Okay, because the law governs consumer protection, sale of land, sale of goods, these are statutes which are written. Where do you see them? Okay, if you were to look or to do some research on Consumer Protection Act, you will see that it stipulates the seller is the person selling, the goods must be of good quality, and so on and so forth. So as long as the goods you are buying are brand new, they are automatically protected under this law. But you don't necessarily see it in a shop. It is common knowledge that when you go to buy goods, you are protected, provided the goods are new. It is a different kettle of fish when you go to buy goods which are second-hand or used, because the Sale of Goods Act does not cover second-hand goods. So if you go to buy a brand new car, you are protected by this legislation, by this law. When you drive the car, you're supposed to have almost 0 mileage. It's supposed to give you X miles to the gallon. It's of what color. It can go into 5 gears and the whole lot. It's either automatic or manual gears and so on and so forth. All of these comes under this Sale of Goods Act. However, if you were to answer an advert in a newspaper for the sale of a second-hand car, you go and you buy that at your own risk, because this law of the Sale and Goods Act does not cover, does not govern used merchandise, second-hand goods. So when you go to buy a new car, you know that you're automatically protected. If when you drive that car out of the showroom and it's not got 0 mileage or near enough, there is always a few mileage for taking it from the delivery or the depot to the showroom. So there's usually a few miles on the clock anyway. So if that is relatively low, it's fine. However, if the engine splutters and it shuts down in the middle of the road and you're not able to start it again with your key, then there is something faulty and you're able to have that car taken back to the showroom. You either get another car to replace it or you get your money back because you are protected. If you were to answer an advert in a newspaper and you go to buy a car which has already been used, you are not protected, and therefore you need to check, double check, triple check that what you are buying is legal. It can be yours. You understand that it's a broken down, half dead car. That's why it's costing you so little, and you don't expect to have the same car as if you're just driving out a brand new car from a showroom. So, you know, the grey cells really have to come into play sometimes, because what you're paying for, you would expect it's not going to be the same as if you were protected by the law of whatever it is, whether it's Consumer Protection or Sale of Goods Act, or even contract of land. So these types of contracts or agreements are special contracts. They must be in writing to be enforceable. If it's not in writing, it can't be enforced. But luckily, one of the few things we see is Sale of Goods Act. We know that we're legally protected because our country protects us so that we get brand new stuff which are fit for purpose. Consumer Protection Act, if you go, for example, to get a loan, you will have to sign a contract for that loan. How much it is, what the interest rate is, how long you have to pay it back, what the penalties are if you don't pay it back, and so on and so forth. So it is in writing and it will be enforceable. And it's the same thing. You go to buy a house, you go to buy land. It is a contract that you have to read, you have to see a plan, you have to accept that the plan is the structure you want to buy or the piece of land that you want to buy, and you have agreed, you have signed that contract, and so you have your monetary consideration, money changes hands, and you are having or signing a legally enforceable document. So statute, even if you see it or you don't see it, if you are protected under the Sale of Goods Act. Consumer protection, your contract will be in writing. When you go to buy land or house, that will also be in writing. And these are enforceable because it won't be incomplete, it won't be vague. They have been tried and tested over the centuries, and even though legislation may change, the contract terms and conditions should change accordingly. Okay, another break. See you in a minute.